The courthouse was grand and intimidating, with high ceilings, ornate woodwork, and an air heavy with tradition. In this courtroom, decisions that could change lives were made every day. But on this particular morning, the tension was different, thick with unspoken assumptions and subtle prejudices that hung just beneath the surface. At the center of the storm stood Dr. Marcus Ellis, a distinguished black man in his mid-40s. He was no ordinary litigant. Marcus was a legal scholar and professor of law at a prestigious university, renowned across the country for his expertise in evidence law. In fact, his textbook, Principles of Evidence, was considered the definitive guide for law students and practitioners alike. Today, Marcus was defending himself in a civil suit concerning a breach of contract, a case many believed to be straightforward, but fraught with complexities only a keen legal mind could navigate. As the proceedings began, Judge Helen McCarthy, a seasoned jurist with decades on the bench, presided. From the outset, Marcus noticed the subtle tone in her questions, questions that seemed to doubt his professional credentials and the legitimacy of his background. When Marcus introduced himself as a law professor and author of the leading textbook on evidence, the judge's eyebrows rose in mild disbelief. "Professor Ellis, forgive me if I seem skeptical," Judge McCarthy said with a cautious tone. "But it's unusual for a litigant to carry such extensive academic credentials and yet appear without counsel." Marcus held her gaze steadily. "Your Honor, I am fully prepared to represent myself. My understanding of the law is thorough, and I believe I can best advocate for myself." There was a quiet murmur in the courtroom as some spectators exchanged surprised glances. The judge's initial doubt seemed rooted not only in the unusual nature of Marcus's self-representation, but also in an unspoken undercurrent questioning his background. The trial progressed with the judge frequently challenging Marcus's motions and objections, sometimes dismissing them out of hand. She questioned his citations of precedent and even interrupted his arguments with an air of condescension. "It seems you are very confident, Professor," Judge McCarthy remarked during one exchange, "but confidence is not a substitute for the practical realities of litigation." Marcus's response was measured but firm. "Respectfully, Your Honor, confidence must be grounded in knowledge and preparation. I assure you, my arguments are based on both." The case hinged on the admissibility of certain pieces of evidence crucial to Marcus's defense. The prosecution sought to introduce documents they claimed were incontrovertible proof of breach, but Marcus argued they were inadmissible under well-established evidentiary rules he himself had helped clarify through his scholarly work. When Marcus cited the standards from his own textbook, the courtroom fell into a brief silence. "How can you be sure your interpretation is correct?" the judge challenged. "Because the standards I cite are the product of decades of research, case analysis, and peer review," Marcus replied calmly. "My work has been vetted by courts nationwide and is widely accepted as authoritative." The trial became a test not just of facts but of perception. The judge's initial skepticism slowly gave way to reluctant respect as Marcus's arguments repeatedly demonstrated clarity, precision, and deep understanding. Witness after witness was examined with meticulous care. Marcus's cross-examinations exposed holes in the prosecution's narrative and challenged the credibility of their evidence. Throughout the trial, Marcus maintained professionalism, never allowing the judge's initial doubts to provoke anger or frustration. Instead, he used the moments of tension to reaffirm his expertise and reinforce the integrity of his position. In a pivotal moment, Marcus moved to exclude a critical piece of evidence, arguing that it was obtained in violation of established legal protocols. After a careful hearing, the judge ruled in his favor. "It appears, Professor Ellis," Judge McCarthy conceded, "that your knowledge of the law is indeed exceptional." The trial concluded with a verdict in Marcus's favor. The breach of contract claim was dismissed.